State you wish any rebuttal.
Yes, Your Honor. Judge, the true test of whether our system can treat people equally under the law is to do a simple reversal of the facts in this case, and that is to say, instead of Mr. Boyd sitting in a tent out in the open spaces, it was an off-duty police officer who was camping out. Maybe he wasn't even in the open spaces, maybe he was 300 feet away in the national forest. When a citizen comes up to him, perhaps with two Great Danes, and pulls a gun on him, and the officer in self-defense, the off-duty officer, pulls out two knives, and there is a similar confrontation has occurred here. And when the officer then decides to get on the ground and follow the citizen's command, the citizen shoots him twice in the side and once in the back. No matter what that citizen said about how afraid he was of the man in the tent, that he had a beard, that he claimed to be a police officer and said he was going to be in trouble if he didn't put the gun down, no matter what he said, under those circumstances, is there any doubt by anybody in this courtroom that that citizen would have been indicted, held in jail on a high bond and indicted within 10 days of him shooting an off-duty police officer to death? That's how that would have been handled if it had been a citizen and not a police officer. And this circumstance has to be handled in the same way. I know Mr. Bregman likes to bombast, but to claim that we have no evidence in this case, the facts that establish probable cause in this case come not from the impressions of the brothers in blue who came in to protect their own, but from the direct, hard evidence. The kind of evidence that has no bias and is incapable of shading the truth. That evidence is something that we've put together in the last 3 months since we've been on the case. We haven't been on the case for a year and a half. We went to talk to the people at OMI for the autopsy. We sent this out for special ballistics testing that couldn't be done here, and went to the expense of having a reconstruction done of this. And what all of that tells you is that they shot him in the back and in the side. And that means he was not a threat at the time he was shot. He was following their orders and was turning to get on the ground. That's something that Detective Sandy said in his statement over and over again, said I think at least 3 or 4 different times. I knew he was turning to his left before I shot. And in this courtroom, both Officer Weimerskirch and Officer Ingram have confirmed the same things. They knew he was turning away, and the only way he could have laid on the ground was to turn to his side and to lay uphill exactly the way he did. All this speculation about they saved her life, he would have attacked them, he would have killed them. We know that he did not do that. He was following their commands to turn and get on the ground. I appreciate the difference between the two officers, judges. It's troubled me as well in this case. Officer Sandy was somebody who chose to do all of this, who volunteered when the call came in, even though he was called off. He made the decision to come and to bring the taser shotgun. As soon as he got there, he traded it off and took lethal cover, his own decision. And despite the fact that Officer Weimerskirch came in here and said it was my plan, in fact, over and over again in his statement, Detective Sandy said it was our plan, and he was part of the plan, and he was making the decisions as well. He rushed towards this because he wanted some action. I don't think Dom Perez is that officer. Dom Perez came because he was activated and called out. Although he was involved, and if you listen to the tape, the first person on the tape, the very first thing you hear is somebody saying, do it. That is Officer Perez saying for them to go ahead with the action, and he was joining into the action at that particular time. However, no matter what kind of guy Dominic Perez is, he chose this job. He chose to be the one to make life or death decisions. And no matter what his training, Judge, no matter how much training he's had, his training cannot turn Mr. Boyd into a threat when in fact he was not a threat. And this testimony about the red dot, and you look at the red dot, you can't see him, I think we demonstrated that with this box. Certainly, if he was looking in his hands, what he would have seen was this, and he would have seen this, and he would have seen this. and he had to know he was shooting a man in the back, something that his own sergeant says he would not have done, and it would not be a good shoot if you shot somebody in the back because they were no longer a threat to you. Reasonable people don't shoot people in the back, Judge. And Mr. Bregman has said, what should they have done? Well, you don't have to look any further than these two officers, right here. Officer Daniel and Officer Hernandez, when they had their guns drawn on Mr. Boyd and were getting ready to pat him down, and Mr. Boyd pulled out a knife this close, with an arm's length of him, they did not shoot Mr. Boyd. They followed their training, they backed away, they maintained a safe distance, and did not shoot Mr. Boyd under circumstances that were much more threatening than the one when there were 19 officers there. It was just 2-on-1 at that point rather than 19-to-1. That's what they should have done. The other piece of evidence that we have, and it is the greatest eyewitness of all, because again, it can't be influenced, is the videotape evidence of the surrender in this case, Judge. Mr. Boyd says, after Officer Weimerskirch's invitation to grab his bags and come down, after expressing for 2.5 hours, not 3, but 2.5 hours, I don't trust you, I don't trust you, I think you're lying to me, I have a right to these guns, these knives, I don't trust your word, I think you guys are lying to me, finally said, I'm coming down and I'm trusting you to keep your word. I'm trusting you. And APD had laid a trap for him, or an ambush. They deliberately wanted him to come down so they could then attack him again. And that's exactly what they did. And the last words he said, right before he was shot, after he pulled out the knives in response to the dog in self-defense in a defensive position, was the cry of betrayal of his trust. He said, don't make fun of people. That's what he said right before he turned to follow their instructions and lay on the ground. That's what he said. What you always hear when a person is shot to death by the police is the same thing that Mr. Roman said. Why didn't they just do what the police officer said and they would not have been hurt or killed? In this case, that's exactly what James Boyd was doing at the time he was shot. And the court should find probable cause on all charges and bind these officers over.
We're going to recess till 1:30. I'll come back and give you my decision at that time. I'd like to inform everybody, please refrain from any outbursts. Either way, if there are any, I will ask security to intervene and recess until I can maintain decorum in the courtroom. We'll be in recess until 1:30. Thank you.
All rise. Good session.
Please be seated. Thank you. Let's go back on the record. Let the record reflect that counsel for the state, counsel for the defendants, and the defendants themselves are all present. Counsel, having considered all the evidence in the case and applying the standard of probable cause as outlined by Rule 14-8006, the court finds, with the exception of involuntary manslaughter, that the state has established probable cause as to all the counts in the amended information. The court will bind the matters over for trial. I'd ask the state to prepare a probable cause determination and also a bind over order. Arraignment will be set at a later date. Are there any questions? Involuntary manslaughter is not included. The involuntary manslaughter, because the court had dismissed those, but the court finds probable cause as to second-degree murder and the lesser included offense of voluntary manslaughter with the firearm enhancements, as well as the other charges contained in the informations. Yes, sir.
No, I'm not asking you to comment on evidence, but I'm asking for a clarification of what standard of law that you're using for this case. In other words, was it a reasonable person or a reasonable officer? Because obviously there's two different arguments being made. I'd just like to be clear for the record on what standard you use to make that determination.
The standard that you argued for, counsel, what would a reasonable police officer in that position have done? Any other questions? All right, thank you. We'll be in recess.
All rise.